the recording has started. So we have got the chat function set up. So I think everybody's done it. Everyone's well practiced in this. But if you could mute your microphones now, and so that just the speakers present will be able to speak. But if you've got any questions or anything you want to put in the chat, then feel free. Myself and Elizabeth will keep an eye on that on behalf of our speakers, and then we can bring anything to you as we go along. So Jane and Chris, can I hand over to you, and let's get this show on the road.
Yeah, and can I check, can you see our slides?
Yes, perfectly.
Yes, okay. All right, good afternoon, everybody.
Yeah, good afternoon. We're delighted to be here. I was just thinking, have we reached peak fair dealing at this point?
I
don't think it's possible.
No.
I don't think it's possible to
Might
have
happen tomorrow. Might happen tomorrow.
Possibly.
Yeah.
We've been doing quite a few events for Fair Dealing Week, haven't we?
So we have, yeah.
We started off with the launch event on Monday.
Yeah, at the Institute of Advanced Legal Studies.
Yeah.
We had an event yesterday.
The Creative Reuse at Kent, where we had presentations from my Kent colleagues looking at how they used and how we've discussed and collaborated with them to determine what fair dealing means in practice. This morning was another excellent presentation of the Scale Coffee Morning, which some of you would have been at, and Deborah, I can see one of the people involved in setting that event up. That was really good, from Debbie McDonald, talking about international implications of fair dealing. So we definitely can't have enough of it, can we?
No.
And we're delighted to be here, and therefore we should move on to do what we're talking about, who we are. So as Sarah mentioned, we run the website copyrightliteracy.org. I think this is supposed to be your slide. So
I think it is, but isn't this the time you were about to play the theme tune?
Was I going to play the theme tune? I can play the theme tune.
People enjoy the theme tune.
People enjoy it, right?
So okay, so we have been running this website and blog, Copyright Literacy, for about 5 years, and I have to say that interest in copyright and online learning.
It's not going to work if I do that.
Oh no, don't do that.
Okay, so I'll have to leave the call if I'm going to play the theme tune. That's all right. You carry on.
Yeah. Copyright and online learning was quite a niche interest, I have to say, till before the pandemic. I mean, I think, obviously lots of universities were starting to think about using the VLE, but they weren't really kind of doing full online courses, or not many of them were. I mean, obviously Open University, some distance learning providers were. But I have to say that it has grown hugely, the interest in topics related to, if I shift my teaching online, what about X, Y, and Z with regard to copyright? So we've seen a lot of interest. We've been running a webinar series as well. And we're continuing to run those webinars on once a month on a Friday at 11 o'clock. So if you want to check those out, if you go to our website and you go to the events drop down, then you can see the copyright and online learning it was a time of crisis, moving to a transition, I think.
Transition is what we're calling it.
Yes, but we will be continuing to do those, and we have been running the ALT Copyright and Online Learning Special Interest Group, which was set up during the pandemic at the end of 2020.
Yeah. So we take a playful approach to copyright. So I think this might be the time where I can actually cue up the theme tune to our podcast and webinar series. Let's see if it's going to work.
It's not legal advice, but it will have to suffice because it's copyright.
We've got to dig around.
All right.
So yes, jingles and theme tunes are only one part of it. Novelty T-shirts, obviously, but it kind of started when we created Copyright the Card Game, the resource we use for teaching copyright, and then the Publishing Trap, which looks at scholarly communication or academic publishing, licensing and copyright choices. And you play the role of a researcher. And then we created the Ice Pops event, which is the International Copyright Literacy event, with playful opportunities for practitioners and scholars in order to share others who also had ideas for creative, playful ways of teaching a topic that was sometimes seen as quite dull or dry or just too complicated and difficult, really. So and that we've had two in face-to-face or in-person editions of that, one online one that we did from this very room last year, and then we are well, watch this space. What's happening in the future? We don't know, but we're
hoping.
We are hoping
we might be able to announce something.
IRL. That would be good.
Yes.
But the card game, we were going to be using the graphics and the icons for that as part of this introductory presentation.
Yeah. So we're going to just sort of take you through what is fair dealing and fair use and how they differ in a moment, but kind of why did we want to get involved in this? I think it does feel like it was very much part of our kind of ongoing mission. One of the things that we really wanted to do when we created Copyright the Card Game was to get librarians and educators and learning technologists to understand what they were actually allowed to do under the law. So copyright exceptions are of all, and talking about exceptions, but then how they relate to licenses like the CLA license, the ERA license, but other electronic resource licenses that you might have for various different databases that you subscribe to. We kind of wanted to understand about the balance between those two things. And we met Kyle Courtney, who is in the photo with us there. He is Harvard's copyright advisor. And it was actually Kyle that set up Fair Dealing or Fair Use Week, as they call it in the United States. They've been running it since 2014, and I think pretty much from the first moment I heard about this event, I said to Chris, we ought to be doing something in the UK about this. So the Canadians got involved quite early on, and Canada has a very similar legal system to the UK. So they actually have the concept of fair dealing in their law. So we didn't have to create new branding and marketing because it already existed. Really from sort of talking to Carl about, you know, how it works, we thought this would be a really good opportunity to actually you know, celebrate what you're allowed to do and to run a week a little bit like we might have Open Access Week and other, you know, kind of weeks that exist. And so we're really pleased that we managed to get a number of events happening. We know there's been some events also happening at specific universities around the country. And, you know, a lot of it is, I think, a tribute to us meeting Carl and sort of seeing the kinds of exciting things that they do in the US, where, you know, it really is, you know, it's a really important part of librarians' work to promote understanding of fair use in the US. And I think they have got a very strong community.
They do indeed. So very quickly, what is copyright? This is copyright in the nutshell. You are going to create the nutshell at some point, aren't you? We're going to have like a tiny little sculpture with all of these things inside them.
Yeah, absolutely.
Okay, so here they are. Number one, subject matter, which we call works, copyright works. These are the things that copyright protects, such as literary, artistic, musical, dramatic works, typographical arrangements, broadcast, sound recordings, and film. Then there are some activity or usages, activities it regulates. These are called the restricted acts in the legislation, which is the Copyright Designs and Patents Act 1988. They are copying, distribution of copy to the public, public performance, communication to the public by means of electronic transmission, rental or lending, and adaptation. There are then a number of two different key ways you can use copyright works legally, and one is licenses, legal uses with permission. James mentioned some of those, but also the Creative Commons licenses fall under that. They are licenses with permission, even though they are very permissive licenses. But the other way you can use your work legally is under copyright exceptions. And copyright exceptions are legal uses without permission. And some of these incorporate the concept of fair dealing. So these, you can see some of these icons. We've got quotation, you've got someone teaching there, you've got recording things, you've got various library related ones. But the ones that we've got here, which are fair dealing ones, are the quotation, your own private study, caricature, parody, pastiche, and illustration for instruction by means, I was going to say by means of electronic transmission. That's nonsense. Illustration for instruction, which is about teaching.
You're talking too fast.
I am talking too, right? You've got me wound up.
Slow down,
so, what is fair dealing?
So fair dealing, like many concepts in the law, but in copyright law specifically, it determines whether a use is lawful and infringing based on what it calls what a fair-minded and honest person would do. So Chris and I tend to run sessions about this. We look around the room, we say, well, we think most of you in here look like you might be fair-minded and honest people. But some of the questions that you might want to ask yourself when you are thinking about, well, what I'm going to do fair, are, well, what might be the impact of this on the owner, the copyright owner's ability to exploit the work? Might it affect the market for the original work? So by the market, we mean if it's, for example, a book or an electronic resource that's available for sale. If I were to do what I'm doing, you know, would it undermine sales? So that if it did, then that's not considered fair. It's also questions about, like, well, have I used the required amount of the work that I need to use? And really, it being fair doesn't specify that you can't copy an entire work, but it does say, have you only used what's reasonable and what's necessary? Which will vary quite considerably depending on whether we're talking about, you know, a 400-page book or one image that you might want to put in a PowerPoint. I'm just conscious here that we haven't kind of explained the 4 factors about how fair use works, and whether it's worth us just briefly mentioning that before we kind of give some more examples of that. People often hear the term fair use because it's an American term, but it is used quite widely on websites, and I think, you know, it's much more commonly used, isn't it, as a sort of a kind of, well, is this fair use? And even people in the UK, many lecturers often will use that as a term. They've obviously heard that more than fair dealing.
So the 4 factors are the purpose and character of the use, the nature of the copyrighted work. They call them copyrighted works in America. We wouldn't use that term over here. And so therefore, so like, is a creative fictional thing different from a sort of factual piece of copyright protected material? The amount and sustainability of the portion used in relation to the copyright work as a whole, and the effect of the use upon the market. So those 4 factors are very broad, or they allow a broad interpretation of a number of different potential uses, and you'll hear that they sound quite similar in a way to what Jane was talking about with fair dealing. The difference is that in America, these 4 factors are actually written down and codified in their legislation, the Copyright Act 1976. In our legislation, we have mentions of fair dealing, but in order to really find out what they mean, you have to look to the case law, and the case law covers sort of various different examples and situations and contexts that you then have to piece things through. And when it comes to education, this can be an interesting one. So if we look at the example that we often get asked about, or when our new laws came in, because in fact fair dealing didn't enter the sort of teaching area of activity in the UK until 2014. Around that time, it was that, is it okay to put images in PowerPoints, or to use images in your teaching and then store those on a virtual learning environment, or then record a lecture and then the images are in there? And I mean, where we've settled on, I think there's a general consensus that, of course, that's fair with proper attribution. That's fair dealing. That's what teachers do. Do we really expect teachers to be going and getting permission and even paying license fees to incorporate images into their teaching slides, if you like? And if we actually look at what happens in the UK under fair dealing, we'll see there are these 4 fair dealing provisions in the law. And in fact, the act of teaching, all of those could apply to them, really. I mean, research and private study, perhaps trickier to argue that, because it's not really there to provide support, providing multiple copies of things to students. But quotation isn't just text, I would argue. And we've heard this morning the work of Tanya Aplin and Lionel Bentley in looking at quotation and actually seeing, is it much broader than text, and in fact going as far as to, you know, images and other sorts of creative reuse. Illustration for instruction was the topic of my master's dissertation, and I always tend to try to interpret that as broadly, I think, as possible. It's the example that we've gone on a slide. The example that was used by the Intellectual Property Office was about putting things on an interactive whiteboard, because I think for them that was a very safe example of what might be covered under that. But we would say it goes broader than that. And caricature, parody and pastiche, doing things where you're mashing things up together, or doing something which is in some way mocking or humorous, I think is part of teaching. I strongly believe that you shouldn't just be teaching people in a boring way. And actually, having a bit of fun, which means in some ways reusing existing cultural things and memes and all that kind of stuff, that's got its place in proper serious instruction, if you like.
Yeah.
I think we've kind of done the next slide, haven't we? The difference between fair dealing and fair use.
Yeah. I mean,
although we do have the link to the...
Yeah, we could pop the link into the chat. We wrote a piece that was published this week on the Harvard copyright blog. I think one of the interesting things is that people do tend to have this perception that fair use is much broader, that it covers a lot, and I think that probably is still fair in many ways. But I think because our law was updated to make it suitable for the digital age, I think one of the things we should bear in mind is that many of the ways that we teach in the digital age involve technology, so we shouldn't be frightened of kind of having a broader interpretation of copyright exceptions generally, but also what we consider to be fair. If we're clearly not undermining the market for a work because we're using very small amounts of it, or we're using it in a way where students wouldn't be expected to go and purchase images, for example, then I think a lot of what we're doing is fair. We also kind of make an interesting historical point, if anyone is interested, that the concept of fair use and fair dealing actually come from the 18th century in the UK courts, where there was this idea of what was called fair abridgment. And actually a lot of the things that used to happen in the publishing industry in the 18th and the 19th century was that people would write great long treatises, huge books, sometimes they'd write them in Latin, and what somebody would want to do is actually write a much more accessible version of that. So the work of Daniel Defoe, all sorts of kind of famous writers in the 18th and 19th century, was really, really often abridged, serialized, reproduced in newspapers, in all sorts of forms. There was a lot of interesting case law around this, because sometimes obviously publishers would say that wasn't fair, but there was also a kind of general understanding that abridging a work was actually changing it. It wasn't just copying it, and it was really important for learning. And that kind of, it was mentioned in the courts at the time that you kind of, to teach people, to make things accessible for, everyday people, to take them out of being in Latin, then you needed to kind of copy the work and translate it and do all sorts of things. So that's kind of where the tradition comes from. And there is a very long history of it being quite associated, I think, with teaching. So I find that quite interesting and something reassuring as well. So at this point, we aren't actually advocating for anarchy in the UK, are we?
No. What is it that I can't remember where you were going with this. Did you want to do a quick rendition of Anarchy in the UK, but with different lyrics?
Maybe
as
a parody.
Make a teaching point?
Yeah, to make a point. No, I think what that has been one of the fears, that we would, if people, and this is what I'm interested when we talk on the panel with some of our kind of copyright specialists, is this kind of where the fear comes from, that if we tell people, well, if it's for teaching, it's okay, is that going to lead to this kind of anarchy where it's a situation of, well, I'm teaching, so anything goes kind of thing. So that was the point I was making.
It's a good point.
And actually, I'm not advocating for that. I'm still advocating for fair anarchy.
Fair anarchy. Okay, that's an interesting concept.
I think we need to be bolder.
Yes.
But I think where I want to end is that, what we don't want to say, and we certainly wouldn't want publishers and rights holders thinking that that's what copyright specialists go around saying is, hey, anything goes kind of thing. Because I think most of us, do take this quite seriously, even when we do muck around, and we attribute our images. And actually, this is a really nice image I got off Wikimedia. So I have cited my source, and I think we'll leave it there. So that's us.
Thank you very much. Yeah.
Yeah. And very happy. I don't know how we're doing for time. If we want to take,
used up quite a chunk of time.
If you want to take any questions,
hand back over.
Pick any questions.
That was
Anyone got any thoughts?
A brilliant start and entry into our discussions here. So thank you guys. I'm going to do the very selfish chair act of asking a question straight away. Which is something that happened earlier. I had a conversation with my colleagues earlier about screenshots. Because and I'll talk about this probably a bit later on because I've got even more questions and concerns about it. We have submitted a chapter for a book and we took a screenshot of a screen from a website, and we've put that in as an image. I'm not saying anything more about the publishers because I don't want to get into trouble. But then, so my colleague was saying, well, I think that's fair because it's a screenshot. I mean, let's not talk about the book bit because that's got all sorts of complexities with publishers. But how okay are we using screenshots generally in teaching materials?
I think it's completely fair.
I think it's very likely to be fair in almost all contexts. I can think of a particular example I was asked about a couple of years ago. Chris, you can probably look this up in the archive there. It would have been one around a researcher wanting to reproduce an image of something that they found on the dark web. This is a dark web researcher. And it's basically what was there from the warning from the FBI, I think it was some sort of government agency that had put something in there, wanted to reproduce that in a book, and the publisher said, oh no, you need to go and get the publisher's or the copyright holder's permission. Now what was in the image was somebody on the dark website, clearly if not criminal, then extremely informal economy at the very least, with things that were part of the government agency. Now in the US, government created content actually goes into the public domain, so there's often, when you're working with US government stuff, less of a copyright issue. But in this case, it was something that clearly had some arguably copyright element into it, but it's like, well, of course that's what fair dealing or fair use or these things cover you for, because they needed to show this to make a point. I think if it's screenshots from commercially available software packages, well, it depends what you're doing. If it's criticism and review, then yeah, of course it is. I mean, what are you going to do? I did follow this up because we're responsible for software licensing with one of our software providers. If it's something where you're actually showing people how to use it, I think as long as you're not kind of creating something that takes away from their packages that they teach people stuff. But we get asked this all the time in library world about, we're doing tutorials on how to use EndNote or searching library databases, and of course that's your job, to show people how to use these resources that you pay. I
don't think I've ever heard of an instance of some company saying that a screenshot isn't acceptable, because I'd say it's a reasonable amount of, if you think of an entire website. Interestingly, and I can't remember whether it's in the first or the second edition of Copyright and e-learning, but I definitely did it in the first edition. There is screenshots from the Amazon website where I was wanting to look at things like the terms and conditions. I quite clearly did not get permission, and when the publisher asked me, I said, no, these are screenshots and they don't need permission. So I just included them as if they were quotations. So I would absolutely, and I would kick back at a publisher if they start saying you need permission for it, to say no, I think this is quotation. It's a screenshot.
So that's really interesting, and I might take this offline because I've got more questions. But this publisher, the publisher won't let us use quotes in their sort of their terms and conditions.
We should definitely put you in touch with Emily Hudson, who's doing research about this exact area. This was the topic.
Can send the guidelines. This is a big, famous, well-known publisher as well. And we were really shocked when the reviewers came back and said, really sorry, but we haven't got the reviews back from the publisher yet, but you might have to paraphrase all of the quotes you've put in. And we're like, but this is an academic book. So it's really
we have to go back to Hubbard and Vosper in 1972, which is one of the key UK case laws, in which it was about a book about Scientology, in which it was a highly critical book about L. Ron Hubbard, in which the author was then sued and then ultimately was upheld to be fair dealing. Now this goes back even before any of this digital stuff. So some quotation, if it's absolutely valid, is there, and it's all about the proportion of it and the context of it. But yeah, that is, we see that kind of cautious behaviour in the publishing.
Really problematic. I will get in touch with you guys about that.
Yeah.
Next person, the first hand I saw was Matteo. If you'd like to unmute and speak your question, that'd be great.
Yeah, hi.
Hiya.
Just wondering how this relates or intersects with the student work. I know that this is probably a bit off topic.
No, not at all. No, and hi Matteo, nice to see you.
Hello, nice to see you.
Long time no see.
So yeah, basically plagiarism. How does this relate to plagiarism and all that?
Do you want to take that one?
I'll let you go first. If you like, I'm happy to take it, but I don't want to be.
No, go on, you take that one.
Okay,
yeah.
So a couple of things around student work. Just to say that illustration for instruction, which is section 32, which is the fair dealing provision, covers those receiving as well as giving instruction. So it covers student work as well. So there's this fair dealing for what students do. So if they are quoting or incorporating work, or in fact, you know, I would argue that you could take this quite far. And I've worked with students who are doing quite sort of heavy pieces of appropriation art type work. I work with yesterday we had a session on creative reuse at the University of Kent, so we highlighted some of this. There will be a recording forthcoming, so you know, watch this space and we'll share that. But a colleague of mine, lecturer Richard Misek, works with film material, and one of his PhD students had basically done this amazing thing where he'd taken all the frames from a terrible TV dramatization of a Stephen King novel and had printed each one out on black and white paper and then had turned that into an animation. And it just created this really weird thing, but it added something. So that's going down the road of creative reuse. That there's a strong justification that you could say, well, isn't he copied the whole thing? Well, in US fair use speak, that is a transformative use. Now, we don't have that understanding in UK, so we wouldn't say, oh, well, it's transformative, so it's okay. But I think still the argument there, a lot of people would say, well, surely that's not, you know, it's not the market for the same work. It's not the same work as an adaptation. But the point about plagiarism is that often the copyright infringement and plagiarism are thought to be the same thing when they're not. They're not the same thing. They overlap. But if you claim somebody else's work as your own, or the theories or the insights that they've made, and say that you've come up with it when somebody else has, now that's plagiarism. But it's unlikely to be copyright infringement unless you're actually copying the creative expression, the words themselves, or reusing a diagram or something which covers that, because the ideas, concepts, and theories cannot be protected by copyright. However, it's possible to infringe copyright without plagiarizing, because if you're not saying this is mine, I came up with this idea, and you're just copying something that somebody else has done, then that can be infringement. So the two are not the same, they can overlap. So clearly, if you are just cutting and pasting chunks out of someone else's work and putting it in your own and claiming it's your own, then it can be both plagiarism and copyright infringement. But it's an important distinction to make, because plagiarism is not against the law. I mean, it's okay. It may.
It's unethical.
It's unethical. It's unethical.
Ethics.
Arguably,
ethical frameworks.
There's actually a really interesting publication on this by an American academic called Brian L. Fry. I'll find the paper. I'll link it in. He is pro-plagiarism. He's saying actually doing this kind of thing.
Don't open that can of worms.
It doesn't really harm anyone, and it's really the academic community's stuck-up attitudes about egotistical, you know, things that they want that makes it happen. And actually, it's a hindrance to scholarship to keep going on about plagiarism. So it's an interesting read. So I'll say
there are some similarities around attribution, is where I would say, you know, in terms of, like, I mean, academics putting things on their slides and not putting any credit, and then kind of castigating their students for plagiarism, you know, putting quotes and not properly citing your quotes on slides. I mean, we all do it when we take shortcuts and things, but I do think that it's all good academic practice, you know, to attribute, and that goes for whether it's an image, whether it's a quote, you know, and
everyone hates a plagiarist. Plagiarism is the ultimate academic crime, unjustifiable, unforgivable, unpardonable. The plagiarist is the homo sacer of academia, sacred outcast, forever accursed.
Is this anyway, what he's
that's what he's written. Yeah. Sorry.
Okay, that's that. We could definitely go down that wormhole another day. I just want to bring up a question that William Haskins has put in the chat. What is the latest thinking on providing online resources to distant learners in other countries under fair dealing? The IPO tell us that you need to ensure that you comply with the law of the countries in which you provide online resources, which is off-putting if you are providing online resource, if you're providing distance learning courses to numerous countries worldwide. Is the IPO advice too risk averse?
That's a really good question. That's actually the topic, William, of the Skirl Coffee Morning this morning. Debbie McDonald from the British Council, and they teach in many countries around the world. So a lot of her job as their copyright specialist is to look into how copyright works in countries where the British Council might be delivering their education. I think I would say that the IPO advice is quite risk averse. In practice, although copyright exceptions vary around the world, we're seeing, in Europe, the Digital Single Market Directive has brought in an exception for teaching purposes that's very similar to our illustration for instruction. So if you're teaching in a European country, I think you're pretty fair to. It's going to be fine in many ways to say, well, if it's covered by illustration for instruction in the UK, it's covered, but under this teaching exception in Europe. Chris is frowning a little bit.
The only issue about exceptions, copyright exceptions for education in Europe, is they're typically aligned with remuneration. So money goes back through schemes that operate in those countries to rights holders. And if you're actually doing something that doesn't fit into that system, and therefore it's not part of a that flow, then arguably it kind of might fall outside. But the law in Europe is changing. But yeah,
but she was also talking about quotation, wasn't she? And the quotation exception, which is is part of the Berne Convention to have this exception for quotation. So it is a kind of in some ways. Applin and Bentley have said it's a bit like global fair use.
They're making the case for global mandatory fair use under Article 10 of the Berne Convention. And they're not saying that therefore fair use does apply to all the laws in the country. They're saying that actually it should be there because actually at the point when copyright laws were agreed to work on an international basis, there should be this international harmonized concept of quotation relating to fair practice. But yeah, the IPO are always trying to steer a line between trying to keep different stakeholders happy, and there was a lot of pressure from the rights holder community as well as from cultural and educational institutions. So the law may actually allow quite a lot, but their guidance will always be kind of don't want to.
But there will be a recording from that event, William, and I'm sure Debbie would be a good person for you to have a chat with about how they interpret things at the British Council. And they do get licenses where there are any sort of concerns about that. They do seek permission for things. So yeah.
Thank you for that, and I'll bring Anita, who's been waiting patiently.
Yes.
Do you want to speak, Anita?
Hi.
Hello.
Kind of linked to the last one actually. A lot of what you were saying, it related back to the effect on the market. So, what would happen if you've got a book which is no longer in print and no longer available?
What would actually happen? I think one of the tricky things about copyright is we often talk about hypothetical situations. What would happen if
it's not hypothetical?
This? Okay. Yeah. Well, nevertheless, even if we've got an actual real example of wanting to do it, it'll be a hypothetical rights holder who may or may not be known decides to take action against you, and therefore you have to deal with their claim that you have infringed their copyright. And copyright infringement, taking legal action is quite expensive and complicated. There is a kind of small track kind of court called the Intellectual Property Enterprise Court. Mostly that's photographers chasing up people for using their photographs online. If you've got something which is out of print, but the publisher, the copyright owner, is still in existence and is still available to contact, then that's separate from if the publisher has gone defunct and is no longer in existence. And there are provisions in the EU laws that actually, and therefore kind of prior to Brexit, we were part of that do put things in place for out of commerce, is the term is used, for dealing with out of commerce works. And this is a major issue for large cultural heritage organisations. I used to work at the British Library. The British Library have got a lot of stuff that they would want to digitise, but they are out of commerce. They want a scheme that allows them to deal with that. And of course, we would all benefit from being able to do that, because there are issues with where it's not economically viable for a publisher to reprint and republish. Their stuff just sits there. But at the moment, I don't think you would argue that this is fair dealing as such. I think you would probably just take the risk that you're going to do it. As you see it happening in America, I've had examples where American books have, an author themselves, for example, has said, this is out of print. My publisher doesn't seem to have any interest in it at all, even though that author has probably assigned the copyright to the publisher. They're just, I'm going to do it. I'm going to put it up there, and there it is. And
so there's some steps you could take, to see if you could, get if the author is still alive, if they could grant permission, if
we know one of the authors is still alive, and a few years ago did say yes, you can use it, but you better check with the publisher.
Yeah, I mean, I think it depends. If you're going to check with the publisher, they're going to probably want to charge you, even though it's out of print. So
the bizarre situation was, originally they said no, it's okay, use it, and now we're being told now you've got to pay for it. It's like,
right,
but you've already said it was okay.
Yeah,
what's changed?
Yeah,
it's a tricky one. I think, given that they've already said you've contacted a publisher, you know that they own the copyright, you know that they want to charge you. If you were to go ahead and use it, then you're in a higher risk situation. And then if you had to argue fair dealing, that would be fairly new ground for the case law, because actually things like quotation, illustration for instruction, as they stand now, are really quite new in legal terms and haven't been tested in the courts. So
illustration for instruction being the prime example. There's been no case law, so nobody really knows. And certainly for the first couple of years, I'd say up to about 2017, no university wanted to say now the law's changed and you can do lots of things, because they didn't want to end up in court and be the first ones.
But there is, I think this area has been addressed in terms of legislation by the out of commerce provisions at the European level, and the issue is that everything that happened then was completely blown out of the water by Brexit, that just totally took over the whole process.
There was going to be a scheme, wasn't there?
So the development of a scheme that works in conjunction with publisher representatives, and so we're waiting. We're in a holding pattern, and there isn't anything.
No,
the Brexit bonus, huh?
Another one, absolutely.
Thank you.
Okay, I can see that Deborah wants to come in. After Deborah, I think we should then move on to the panel discussion.
Brilliant. Deborah? Yeah, please.
I was just going to ask whether what you think the risk is if you contact a rights holder asking for permission and they just don't answer, and you then decide, oh well, I think I might just rely on fair dealing. If they later complain or have you weakened your case by trying to contact them in the first place? I guess is my question. Are you better just to say, well, I could contact them, but I think I've got a case for fair dealing, I won't bother? Or do you think it's good to make the attempts to ask for permission, I guess?
Shall I go for that first? Yeah. I think that's a tricky one, because if you're fairly sure that it is covered by fair dealing, I'm always a little bit, I do think that contacting the publisher, then you have to be prepared to pay it, and to, because in doing that, you're kind of then asking for a license, and they're, whether or not it is covered by an exception, they're not going to say, oh, by the way, you don't need to pay. They'll be saying, yeah, of course, yeah, you want to pay, you want this, right? What should we charge? £250 or something, £500, how many students? So I think it depends, if you're kind of tipping the balance into the fact of thinking, well, this is probably fair, I would be inclined not to get in touch because, you know, in the past, I think people used to have this idea as well that they could get in touch with the publisher and just say, oh, if I don't hear from you, I'll assume you've given permission, which is, of course, not a very sensible thing to do. But I think, you know, if you are going to contact them, then I kind of think you just have the wadges of cash ready, because they will give you a price if they come back to you. They're not going to just say, oh, I think that's fine, actually.
I would agree. I think that, so I put that link to the University of Kent's guidance on copyright risk. So there's these four, they're not the four fair use factors. They're developed from what Charles Oppenheim has for many years been talking about, these four things. What's the likelihood that you're doing infringes copyright? How likely is it that the rights holder will discover your activity? How likely is it they'll reject or object? And then what's the impact, reputational, financial? And the thing about that is you're tipping the balance more towards, you're increasing the risk because you've told them and you've alerted them. And I think it's guarding against what turns into permissions culture. And I'm thinking back to a number of these times we've done surveys around copyright and attitudes to copyright. And sometimes we've worded the questions around licenses and exceptions in ways that, you know, we would think, are you more likely to rely on a license or an exception? And people tend to go for both, because what people want is, they want certainty, they want to be able to use the exceptions, but they kind of also want to use the licenses. And I think when you're dealing in this area, you kind of have to go, you know what, using, like, getting comfortable with risk means taking a risk. It doesn't mean I'll take a risk and I'll have some certainty by asking as well. It's like, no, you're kind of, in trying to reduce the risk, you're probably increasing the risk. And you just have to accept the fact that it's got some risk, but that risk is manageable.
Thank you. Just one more. I can
just see Kenneth's point as well. If you go ahead assuming it's fair use or fair dealing, and the publisher isn't happy, the first action is likely to be, yeah, I think so.
Yeah, it is.
They're not going to take you to court immediately. You know, they're not going to send in the copyright police and have you slung in jail. The most likely thing that will happen at that point is they'll say, you need to pay us for this.
Mm. And one last question from Jago Brown. It's in the chat. In a VLE, when we add files, should we sometimes be adding the source URL as well as the license, so we can quickly determine the source later?
There's actually a rather helpful, lovely screenshot.
Indeed.
Yeah.
Illustration.
So it's not just a random question. It's one with a big arrow pointing to a particular field. That's my kind of question.
Yeah. I think that's helpful.
Yeah, it is. I mean,
I can't imagine many academics would do that.
Yeah, I mean, it's related to what happens around the Creative Commons licenses.
It is, yeah.
If you're attributing according to Creative Commons licenses, you should be providing a link to where you got it from and to the license itself that you're using. So if you can, then you should. But we know that the issue is time is precious, and often people don't.
Yeah, that's from Moodle, isn't it? Where you're adding the file, or is that a Blackboard thing? I think
it's Moodle.
Yeah.
Yeah.
I mean, I think the only thing I'd just say as well, on the Moodle front, because I've noticed this myself, is so our Moodle at City is set up in a way that by default, when you upload a file, it's actually saying that you own it as the person who's uploaded it, and that you're putting a Creative Commons license on it. And I suspect almost everyone is not changing that default, which has always slightly concerned me. Even though I'm like really super pro Creative Commons, I'm not sure it's raising awareness of copyright. And sometimes, I mean, for example, when I'm teaching with my colleague Julie, we've created the slides between us, and I'm thinking, now I've kind of just taken, you know, I've just, it's basically it's adding a license, a Creative Commons license, and it's saying that it's mine when it's our joint work. Or sometimes I might be adding slides that Stephen might have done a guest session for me, and I add his slides, and then it's, you know, unless I change it, it's coming out, you know, which yeah, I would kind of question how much, when we're teaching people how to upload things for the VLE, we're kind of doing copyright training at the same time? Because I think we're probably not, and we might be missing a trick there. That we could do a bit more.
I think people want help when they've got a practical thing they need to do.
Yeah.
We like to involve them into a wafty philosophical conversations. It's like, can you just tell me what to do? I think we need to get better at bridging that gap.
Yeah.
Fair enough.
Thank you,
Thank
Jago.
you.
That was a
Thank
really excellent question to get us thinking, and maybe something for the Bleed to take forward as well. So we have just over half an hour left of our session this afternoon, and it's now time for our panels. So I'm going to invite, although you're all on screen, I'm going to fiddle with Teams and see if I can highlight you. But we've got Jane and Chris are going to be joined by Sam from UCL and Stephen from City to kind of talk about their own experiences and practice. And I'm going to ask Elizabeth to chair this session. So I will hand over to you, Elizabeth.
Thank you, Sarah. And welcome, Stephen and Sam, if you'd like to unmute when you're ready. So who'd like to get the ball rolling on, in your context, how does fair dealing work for you?
Well, as a copyright officer in a higher education institution, one thing I wanted to talk about was the role of the CLA higher education licence, because it's key for copying for educational purposes in higher education. I think probably every university in the country has one, and the thing about copying and sharing under the licence is that the licence provides a guarantee, as long as you follow its terms and conditions, that you can't get into trouble for what you do. Whereas fair dealing, you can be challenged. So it's important to remember that you have the protection of that licence when you're copying, and which allows you to copy specific amounts. So it's not open to judgment, as it is with fair dealing, for specific educational purposes, like making available through a secure network, or even just the copying that students and staff might do for their own purposes. So I don't know how many people in this session are familiar with the licence, but it's worth being familiar with. And it should be the case that next to photocopiers in higher education institutions, there'll be a notice that is issued by the CLA, and certainly at City, I'm under strict instructions to try and make sure that there is one of those notices by every photocopier in the institution, which is often not very easy to do. Excuse me. So that's my first thought, that everybody should be aware of that, and perhaps may not be. It's obviously as a copyright officer, it's part of the bread and butter of my job, but if you're not a copyright officer, it may not be, and you may not be aware of it.
I was going to say, Stephen, that no, we don't have them at UCL at every photocopier, but I do remember seeing them when I was teaching by a photocopier, and I think that might be a scale thing. And we have a ridiculous number of devices because we are a ridiculously large organisation. But yeah, if I go from there, so I'm a faculty learning technology lead. So I'd say for the last 2 years, my job has been supporting the transition to online and blended learning. And with that, that's posed some interesting things. So part of what I do is encourage use of formal reading lists that are obviously connected to libraries. So we know it's a legal access copy. People still upload PDFs. You get this line of oh, but I got it from a legal source. Well, we don't know the source because you've uploaded it from your desktop, and we can't prove otherwise. And we kind of got an interesting situation. So obviously a lot of encouragement. I do an awful lot of open education work and Creative Commons stuff, and I push that as much as you can. Obviously, if people are including things in presentations and so on in their materials, but there's some interesting things in architecture where there's some buildings where the design of the building is so protected that you're not even allowed to take a photograph of the building for a certain amount of time, and that becomes really interesting, that you want to talk about these buildings for teaching, but because there's such high protections that it even becomes tricky under fair dealing potentially to do that. So there are some very kind of tricksy things in some of the fields Yeah, Chris, it's quite scary actually. Yeah, things like the Syndicate, yeah, and it comes up a bit in kind of architectural history on that. So, and I say that obviously I produce a lot of guides, so there's all this screenshot stuff is bread and butter to what we do, and we make screen captures of demos for people. So I think personally in my own work, I rely very heavily on that notion of fair dealing for instruction for colleagues, because I'm instructing them as their instructor in how to do stuff. And I think it's the same for them as students in all the training roles that I've had, the manuals and everything we've produced, we rely very heavily on that. But I think it's been an interesting one in that I think people, you know, and I used to have this argument all the time when I was teaching about students would just take a picture of the internet, because if it's on the internet, then it's open access, right? They assume that because they can freely view it and see it, they can freely reuse it. And that's not necessarily always the case, and that's kind of still very much a learning point, and it's kind of something that still comes up an awful lot in HE actually.
Yeah, that's very interesting to learn about the architectural issues. Obviously some subject areas do have their own peculiarities, so like music, sheet music isn't covered by the CLA license, as a separate licensing scheme for that. And yeah, so obviously in cases like that, fair dealing is still important.
Thank you for that. Chris, you look like you were about to say something.
Yes, yeah. I think a couple of points to pick up on. I would say Stephen's absolutely right to talk about the CLA license and licenses in general, but when we're talking about fair dealing, we're not saying fair dealing is the way in which you do everything. It's fair dealing, and we put this in our University of Kent copyright literacy strategy to say it is a vital supplement to the licenses that we have. So we have licenses, we pay. Your copyright is about getting fair rewards to people who create material. And I certainly wouldn't, well, there are various philosophical discussions you can have about that, but nonetheless, it's a system, that's how it works. The money does flow back. So you've got them, and as Stephen's saying, you kind of almost can't go wrong unless you accidentally scan too many pages or whatever. But having the posters by the photocopiers. So we used to do that, and when we got audited by CLA, we went around and showed them, and there they were, and excellent, you've done well with your audit. But actually, under the license, you don't have to have their poster. So one thing I did want to do was actually create a new poster, and a new poster that, along the lines of what I've seen some American librarians, for example, copyright librarian Nancy, I can't remember. Nancy Sims was in her institution, has got one that's basically saying, you know, fair use does exist. You know, it's different in US institutions because they don't have the equivalent of the CLA license. It doesn't really work like that. But I think there's a real opportunity there if we want to raise awareness of saying, now you've got responsibilities, you've got rights, if you like, things that you own copyright. Some way of combining that into some communication was always something I was keen on. But yes, CLA license is important. On the subject of architecture, yes, architectural buildings, there's an argument to be made that what your buildings and designs of buildings are protected by copyright, absolutely. And if you were to go and build a building based on a design, that can be an infringement. There's a whole thing in Lionel Bentley's, what he's saying about this global mandatory fair use, about architecture and quotation, very strong thing then. We do have a provision in the law which says that taking a photograph of a sculpture or a public building is actually not an infringement of copyright. Section 62, I mean, that's artistic work, so that's sculptures. But it's related to this concept of freedom of panorama. So we do have, and that's about being able to take images of the built environment and that not to be subject to the same restrictions. It's different in European countries. In France particularly, they've got those provisions around
the Eiffel Tower at night.
An Eiffel Tower at night because of the Soleil Lumiere, because the actual light show itself is protected by copyright and therefore your reproduction of it. And there was also some case law against Wikimedia in Sweden around
photos of public
photographs of public
sculptures.
Yeah, so I'm not saying it's an area that doesn't have any restrictions, but it may be that if we've got people with who are responsible for these public buildings, they may well be overreaching what the law actually allows them to do and just saying you can't do that. Maybe more of an issue around trademark. I'm thinking of an example that I probably shouldn't mention that involved some legal action somewhere I used to work. But that's probably as much as I need to say.
I think this is a particular style of obviously it was built privately as a house, and there's a particular style to the building that I think is weirdly counted as a trademark because of their specific style. It's really interesting. It's a specific set of buildings.
And I'm thinking now about dance. My mind is never far from dance, but it's another area. When we talk about copyright, sometimes we think about books and journals, particularly those of us that work in libraries. But I also had.
You think about music and dance.
I think about music and dance and sound and light. And it was a Fosse, Bob Fosse.
Yeah.
And the choreography is protected as dramatic work. But then what we found is if you're then saying you're teaching people the Fosse technique, now that is trademark, and that's a whole business around
there's the thing about yoga as well, isn't there?
Fosse yoga?
No, not Fosse yoga.
Please, not that. Please, I'd love to see Fosse yoga.
Yoga that they tried to say was
yes, yeah,
was protected, but it was on my copyright X course.
The advice I get, and again, Chris, later have a look for the Fosse one because that's quite a good one in the archive. Is ultimately saying, well, no, the actual teach or analysing and looking at Bob Fosse's choreography is not an infringement of copyright. But if you are perhaps promoting what you're doing as if it's looking like you are teaching the Fosse technique, then that's trademark, and they're very, very hot on that. So there's all those kind of dividing lines. But I think it's really important for those of us in education to stand up against, not just go, oh, actually, they're quite aggressive. Let's not go anywhere near that. It's like, hang on, we want to teach people about architecture. We want to teach people about dance. We can't just not teach 20th century contemporary dance students about Fosse because we're scared that they're going to charge us some sort of license fee or just ban us from doing it because they want to run their own lucrative courses. So that's just my thoughts on that.
Thank you for that. I'll pose a question if we don't have a question in the chat. One of the things I was just thinking was, what's the most common fair use or fair dealing query that you get?
Can I put an image in a PowerPoint?
Of course you can. You just need to not say that you found it on the internet and therefore it's okay.
In all the years I'd had it, I think it would be about images in PowerPoints, and then obviously now images in lectures that are being recorded. I know we've got a few other copyright specialists. I don't know, Stephen, what's the most common question you get asked?
I think the images one is probably it.
Yeah.
Particularly in theses.
Oh yes, images.
Sometimes because people will put pictures in, and by pictures I mean possibly a painting or something like that. So I came across a thesis the other day which had a large reproduction of a Magritte painting, which is still in copyright. The thesis was actually about engineering, if I remember correctly, and I couldn't see any good reason for it to be in there in his text. And I just thought that can't stay because it's a large reproduction. If it had been small, I wouldn't have been so bothered. That would have fallen more within the confines of fair dealing, I think. But it was also the fact that I couldn't see any possible
it was literally just there for decorative purposes.
I can only assume he did have a purpose in his own mind, but unless I didn't look far enough, I didn't find it. Anyway, he was perfectly comfortable with it being redacted. He didn't put up any argument, so that was all right.
I remember the thesis you showed me. I think it was shortly before I came to work at City. I came over to chat to you. Do you remember the thesis that was? You can probably remember
Jamaican music.
Jamaican music,
Sorry.
yes, and it was all the album covers, wasn't it? And we had a discussion about whether those were quotations or whether they were, whether it was fair to have them. And they were very small as well.
Indeed, we did, and I really did not want to take them out because
No.
I mean, this was when I was perhaps less experienced than I am now, and I was thinking, you know, these things are probably not in circulation. They're not going to damage the market for the albums in any way, and they are integral to the thesis because it was part of it was an analysis of album covers, if I remember correctly. So,
Yes.
So yes, we left them in, and I really don't see why not. But it does, you know, make you realise that there's more to fair dealing sometimes than might meet the eye. You can sort of find ways of meeting the fair dealing criteria if you look hard enough in quite a lot of cases where it might not be immediately obvious, like the, you know, reproduction of an entire illustration, but it's just a thumbnail, as it was in the case of those album covers.
I'm going to say, for me, I think a lot of it is, I think people probably don't think enough about the inclusion of images in their PowerPoints for them to ask the question quite often. I think video, so video clips, YouTube, those kind of things, recording of, I mean, we have interesting, even just about recording guest speakers, and album for that is interesting in that it effectively assigns everything to the institution, which upsets a lot of guest speakers. So there's, like, you know, various versions of departmental copies of that form, but it tends to be around video. And obviously we've had problems where, you know, where people have used Boxer broadcasts, you know, and they used it really heavily in their teaching pre-pandemic, but because of the license on that, they couldn't use it at all because of the global nature of their students. You know, and because it's a licensed thing, you can't justify it still being in there under fair deal. You know, so it's kind of been a bit interesting, but yeah, it tends to be video, YouTube, that kind of thing that gets the questions, because we know there's things on YouTube that, you know, maybe shouldn't be on YouTube and are potentially an infringement in and of themselves, and then reproducing that in a teaching context can also be interesting.
Interesting. Just one aside on this area, you're prompting queries from the audience, which I'd be interested to hear. On Monday's event, we had to sign the consent form to be recorded as part of the IELTS thing. Didn't include anything about fair dealing. So we said, right, okay, we're going to have to put that in because
can we modify your consent form?
Which they absolutely agreed to.
Yeah.
Very nice to hear about modelling practice.
Well,
it's so unusual.
I was going to say, I'm talking at the Times Higher Digital Universities Week in a couple of weeks, and the form I've had to sign for them is actually I've had to sign away pretty much every right ever and agree that I would take on the legal action if I happen to say something that ensued as, and it's quite terrifying signing that. You know, it's quite scary, actually. I'm only on a panel. I'm not actually giving like a 20-minute talk or anything. I'm literally on a panel.
Show loads of YouTube clips. Loads of them.
and dub them with foul language.
Oh, it's just, it is quite scary, actually.
But can we open it out about whether
that would be nice.
Most common queries? I'm really interested in, you know, what are they?
Copyright question bingo.
Yeah.
It gets house first. If you don't want to type it in the chat, if you just sort of signal with your hands, you can then unmute. That's not a problem.
Just one other one actually that I used to get quite commonly was, oh, but it's my book, so that's okay, isn't it? I've just uploaded the whole thing. That was another one of my favourites that I got quite frequently when I worked.
Yeah, that was always very reassuring to hear that. Yeah, you'd hear that, and then when you check, they'd signed over without realising.
Yeah. And I had to explain to them about how assignment of copyright worked, and why they didn't actually own their book anymore.
There's also things about your research as well that you can put like a pre-version in the institutional repository, because it's not the finished version that the copyright, you know, there's kind of those funny, weird things about the preprint sharing as well, on research papers and things, and which version goes in and stuff, which is interesting. And dare we say, the horrendous fees associated with open access publishing if you're in a journal of some note. Thankfully mine were waived, but it was around $800 was the gold open access publishing fee that was waived, thankfully. But
I was just looking at an international journal related to educational development from a large UK-based publisher. They want £2,300 to publish gold open access.
But I think if we're thinking about open access, I think the real challenge here, and it's something we are going to be following up with Martin Eve to talk about, is incorporating images under fair dealing in open access publications, because the whole process of getting permissions and publishers being comfortable with third-party copyright content is based on a print model. If you ask somebody for permission to use something, they'll say, well, how many copies is it? It's like, well, it's going in a repository, or it's going in an open access publication. And then you've got, when we're talking to PhD students, so Stephen, your example, and we deal with that all the time, and what we do at Kent is we've created a checklist so that we work, it's optional for the author to go through and identify the content, and it puts fair dealing right in the middle of that. It doesn't say ask for permission, it says, have you asked for permission? If so, who from? Or is it fair dealing apply? And if so, we'll work with you. We can put a risk score against that. And then it's the author's decision as whether they incorporate it. But in some ways, what we're trying to do with that is get them into the mindset that they will need to do research into the copyright if they actually want to publish that at some point, because a publisher will almost certainly want them to get permission, or at the very least, if they want to rely on fair dealing, they'll have to argue the point, because the publisher won't go, yeah, no, that'll be fine. So what we want to be able to do is to influence the publishing industry. This goes back to mention of Emily Hudson and Tanya Aplin's work. They're talking directly to publishers to see what kind of quotation norms they have. But really, I would think we need to be very, very careful of this view that because something's going to be open access, it therefore, and it's under a Creative Commons license, and therefore could be made available, and you're giving permissions as the author for unlimited numbers of copies to be made, that therefore the copyright permissions process should be harder or more expensive. I think it actually should be going the other way. It's saying, well, actually, open access isn't about creating profit. It's about creating a sustainable scholarly communications ecosystem. And we don't want to be inadvertently creating a secondary or tertiary market for publishers to rinse everything out of the system, seeing as that then, if we're turning the tide against those exploitative licensing practices, let's not go down that road of just going, oh, is it okay if I use this chart from this other publication? And then they say, or whatever. But it's a complicated area, because we know that in his area in humanities, a lot of the bodies that are providing this permission are cultural institutions, their museums and their galleries, who are severely underfunded. So it's not as easy to say, yeah, we should just use fair dealing all the time. It has to be part of a concerted effort to have a sustainable system that actually keeps the public funds within the public bodies that are teaching and preserving and making things available, and not having it drain out into sort of profiteering places.
It's probably also, if you could pop the link into the guide, the Code of Fair Practice for creation of OERs, which does have a section in it. It's an American guide that was created last year, but it does have a section about third-party content, and how just because you might be creating an open educational resource doesn't mean you can't put third-party content in, but you have to mark it very clearly as saying this is not got the Creative Commons open license on it, but everything else has. And actually they argue in the code that if you take this stuff out, if you take the kind of, then actually it can, or you put just a link to it and things like that, it makes it much harder for somebody to reuse your open educational resource. So we have been quite interested in, there is a kind of Canadian interpretation of this guide, and we have been interested in a UK interpretation of it, haven't we, as well, and how it would work.
Absolutely, we are.
Okay. Kim's got her hand up. Kim, would you like to take the mic?
Yes, thank you. I've found this so interesting. It's been wonderful.
Thanks, Kim.
I'm making loads of notes, and I'm thinking, gosh, I wonder how many of these notes are now copyright. But no, let's not go there. One of the things, an interesting thing has come up, a book that I am a co-author on has been out of print for a very long time. The publishers won't reprint it because it is dated in some way. We want to write another book that sort of is not the same, it's not a new edition of it, but to update lots of the ideas, but we want to be able to refer to it, and we want our readers to be able to get access to it. So we've applied for open access.
Right.
We've gone to the publisher. I went through IOE colleagues, gone to the publishers who've said, we can't find any agreement about the publication. What have you got that's in an agreement about it?
Really?
We're in a no man's land because we've got nothing.
No. When was it published, Kim? Was it more than 25 years ago?
No.
Right.
Well, even so, in the absence of there being any contract, them saying they haven't got it, I mean, it doesn't mean you're out. You can just do what you like with it. But without a contract saying that there was a license or an assignment of rights, then the authors, you own the copyright.
Mm.
If they haven't got anything, they can't. But it puts you in a tricky situation, because if you were to then use it and then they were to find some evidence, or I mean, there is still this thing called an implied license. But in some ways, that if that's the case, where you haven't got anything written down and it's just they've acted on the basis that they have permission to publish it, that is legally, that stands legally. You wouldn't then be able to say, well, you've lost the contract, which means you haven't got the right to actually have published it in the first place. It's a complicated scenario if they've lost it. I'm thinking this through, thinking it isn't a straightforward thing, but I think you're in.
You should be in a strong position.
I'm saying you're in a pretty strong position, because I think you could say to them quite politely, well, hang on, if you can't even find the contract, surely you could just hand this over to us, because effectively the copyright, by your actions and not to say it in these terms, by your incompetence, then the rights will revert back to the authors and give us the right to do what we want with it.
Oh, now that could be interesting. We won't do it bluntly, but
no,
because it's actually stopping us with the writing and publication of the new book, which is not
the new book. Yes. Yeah.
So it's a bit of a challenge there. Thank you very much. That's really interesting.
Well, good luck, Kim. Good luck. I hope you do manage.
The only point I would make at the end of it is, if we're thinking from the fair dealing perspective, now if what you're going to be doing is incorporating quotations and aspects from it, then what fair dealing is potentially a route that you can go down. I mean, you don't not quite sure what the copyright implications are, but then if you look at those fair dealing factors and tests, is it really competing for the market? Are you using any more than you need to? Well, it's a new work. They might say it's an unauthorized adaptation of an existing work.
It's a fair abridgment.
But you could say it's a fair abridgment. Let's go back to 1745.
Quote some copyright history out of them. And wasn't there a landmark case related to the University of London?
There was in 1911. Yes. There was also, in your comment, Kim, about taking notes and whether there's copyrighted in. I'm also thinking about Walter V. Lane in 1900, in which some Times reporters took down a speech and transcribed a speech by Lord Rosebery, printed it in the Times. And there was a court case there about who owned the copyright in that, and it turned out that the reporters did, because their transcription was an original work, and that is still seen today as being good law. I had a conversation this morning with Chris Kent about whether an artificial intelligence transcription had the same. Sorry, I'm going down a rabbit hole. But it's a very interesting.
Chris, is this where that you get that junction of the intellectual property is the person that gave the speech, but the transcription is the copyright of the person that transcribed it?
In my view, the way that it really works is that the person who's delivering the speech, the words are transcribed accurately. That means that there's a literary work that's now been fixed, copyright arises, and it's the person who thought of the words has clearly created it.
Yeah.
But there's just some weird thing about originality. When you really if you really want to get into the copyright, the originality thing is fascinating, because it doesn't mean what you think it does from a layperson's perspective.
Because also that thing on digital images of, obviously there are paintings that are out of copyright because they're paintings they're using, but the digital image of that painting is under copyright.
Very controversial though, very controversial, and not going to be possible in Europe, is it? I think
No, but if we can go ahead with Ice Pops, we might hear some more about that.
Yes.
Ooh, it's all to play for, isn't it?
Yes.
Thank you very much. That was really informative. I really enjoyed it. Thank you all for your contributions and the questions. Really, lots of thoughts. Have just started off, and I'm going to be following them. Sarah, do you want to take up the next part?
Yeah, I mean, there's just so much. This has only been an hour and a half. I mean, I can see why Jane and Chris do a lot of this copyright business, and and you've had a week of fair dealing. But I mean, I'm wondering if we can invite you guys to do this again for us next year. Presumably there'll be another fair dealing week next year, if that's something you'd be up for. But
hopefully in person.
That would be mind-blowing. How weird and awesome would that be? Absolutely. So we have our Bless group, which is made of representatives from the Bloomsbury colleges. We will follow up and send emails to our group, but everybody who attended today or who was sent the invite will get a copy of the recording. And if we've got any, are we all right to send your slides, Jane and Chris? Are you happy for us to do that? That would be excellent.
Yeah,
there were lots of really useful links in the chat and stuff, so hopefully that can be somehow collated, and I think it will be in the recording. I think that's how it works on Teams. And in terms of the Bless group, as I said, we have a meeting every term. So for those of you who are members of that, or if you're not yet a member but you belong to the BLE and you'd like to join the list, we'll make sure you get a sign up for that. But let us know, let myself and Elizabeth, we co-chair the group, if there are any topics or anything that you would like us to cover in the next meeting, which will be sometime next term, probably June-ish. I think, Elizabeth, before people disappear on holidays, which I think we'll be allowed to do this year.
Yeah.
Come back to us if you've got any topics you'd like us to cover. But yeah, I don't know if anyone has any other questions or comments. Stephen, I can see you've come back on screen, which is nice. If anyone else wants to show us their interesting backdrops, I've got a very messy room behind me, which is trying to be blurred. It makes it look even worse. But if not, I'd like to thank you all for joining us, and particularly Jane and Chris for all of your wisdom, and then for Sam and Stephen for joining our panel. And thanks, Elizabeth, for chairing that.
I think Chris would like to play us out with our new jingle. If you haven't heard our new jingle.
I think that would be a lovely way to finish off the meeting. So go ahead, Chris, that'd be great.
Thank you very much. Right, let's see if this is going to work.
And so our webinar comes to its end, and we know you have to go. You only set aside enough for this, but there's one more gift we'd like to bestow. One last we know it's down to day and lunchtime's but one last thing, please stay around for one last thing, one last thing.
We don't actually have any one last thing, do we?
We don't have it. That is the end. Yeah, but we do play that now at the end of our webinar.
Brilliant. Thank you so much, all of you.
And I hope you enjoy my harmonising. Now, I am actually singing on that as well. But I've been largely faded out.
Thank you all.
All right, lovely to see everybody. Really good event.
Thanks everyone.
Elizabeth, and thank you.
Thank you so much,
Sam, for joining us.
Thanks.
Thank you. Stephen, see you tomorrow.
Yeah.
Cheers, everyone.
Yes,
Bye.
will do. Yes. Thank you all. Goodbye.
Bye.